First District Court of Appeals now in session. All who have business before this court draw near, give attention, and shall be heard. May God save these United States, great state of Florida, and this honorable court.
Please be seated. Good morning. Welcome to the First District Court of Appeal. We have two cases on the docket this morning. Between the first and second case, we will take a break, and we invite counsel to have coffee with us in the rotunda. The first case is Betterman versus Swearingen, 21-21-27. And Mr. Brown, are you ready to proceed?
Yes, sir.
You may proceed.
Please, the court. Good morning. I have the honor of representing Eric Betterman, the appellant in this case. My name is Chris Brown, for the record, and it is actually my first time before this court, so it's a pleasure to meet y'all.
Welcome. How much time do you want to reserve for your rebuttal?
I would respectfully request to reserve 5 minutes, please.
Okay, got it.
Unless the court has any preliminary questions, I'll go into my presentation. This is an interesting case, which is...
Mr. Brown, would you grab that mic and just move it a little closer to you?
Yes, sir. Is that better?
That's perfect.
This is an interesting case, as often cases are that make it to this level, in that we have a statute in the state of Minnesota which, in the appellate's position, criminalizes an entirely different type of conduct than the statute that the lower tribunal has described as similar in holding that he is subject to registration in the state of Florida. What this case turns on...
So, Mr. Brown, the way I see it is, in the state of Florida, having sex with a minor is a felony that requires registration.
Yes, sir. Absolutely.
Afterward. Okay. So, in the state of, was it Minnesota?
Minnesota, yes.
In Minnesota, having sex with a minor who is older than the age of 16, but is under familial authority or school authority or something like that, is also a felony requiring registration.
That is correct.
So why are these not similar?
Well, and although the brief was done in two sections, as we said in the beginning of section 2 of the brief, the issues are almost conflated. So one of the issues is, what does the term similar mean? The argument of the appellant is that the lower tribunal should have applied the rule of lenity, because the entire argument of both sides is what is similar, what the court just said. It's the defense's or the appellant's position that similar should be given the definition most favorable to him. That's based on the Causation case, if I'm pronouncing that correctly, which is 991-803. And the reasonable construction.
But the rule of lenity doesn't apply unless there's ambiguity, correct?
Well, that is absolutely correct, Your Honor. If there was no ambiguity, then the court does not need to look beyond the plain language. But the problem here is, since they didn't define similar, and similar is a prosaic word, and there are multiple definitions, that's the ambiguity is not in the entirety of the statute, but in the word similar. And the appellant's position is there's this definition, a common definition of Webster's. It's the first definition listed, which is strictly comparable. The appellee has responded saying these do not need to be identical statutes. I want to be clear, it's not the appellant's position the statutes have to be identical to be similar, as our legislature has held. But strictly comparable, if that language is applied, we could demonstrate they are not strictly comparable. For instance, and there are two reasons they're not, the appellee has pointed out, and it's a good argument in their answer brief, it's hard to imagine a scenario under which someone can be convicted of the Minnesota statute but not the Florida statute. But the converse is not true, and this is the big difference here. Minnesota's age of consent is 16. Florida's is 18, obviously. As a father, I was actually surprised, father of daughters, to see that there's still states with 16 as the age of consent. But Minnesota's general law is any person of any age can have a sexual relationship with someone 16 or 17. They then carved out an exception. It's a standalone statute saying, except if that person is in a position of authority, is the term that's used in the statute. Whereas Florida's section, which the lower court has held to be the comparable statute that is similar, 794-0118, is a subsection of our general sexual battery statute. So as Judge Roberts said, you have a statute in Florida that says it's always illegal to have sex with a child under the age of 18, over the age of 12. Of course, under 12 is capital. And then a subsection of that same statute creates an enhancement for which Florida describes as familiar or custodial authority. So those are two differences. Florida's is an enhancement of something that's already a crime. Minnesota's creates a crime for sex that would otherwise be lawful. And Minnesota's also uses the term position of authority, a broader term. Florida's statute says familiar or custodial authority. So there is a situation where someone could say, well, was this person, the appellant, in a position of familiar or custodial authority? It's without dispute in the record that he was the coach of the victim in that case, but he was convicted under the general term position of authority, which certainly a coach would have.
But you agree that if this activity had occurred in Florida, that Mr. Betterman would have been convicted of a felony and had to register?
If Mr. Betterman had, I'm not trying to dodge the question, maybe rephrase it a little bit.
The same activity, had it occurred in Florida?
Yes.
Okay.
But Mr. Betterman would also have been convicted of a felony if he had sex with any 16 or 17-year-old in the state of Florida, even if he wasn't their coach, even if he had met them on a website or at the mall or through church or some other means. The Florida statute that we're describing as similar or potentially similar is an enhancement of already a crime. So if Mr. Betterman had had a relationship with this young woman in Florida, it would have been criminal because of her age alone.
Sure.
In Minnesota, it was not. It was criminal in Minnesota.
And then in Florida, there would have been an aggravator in Florida, so it would have been a worse crime in Florida. But still, the original crime would require registration.
Right, but if let's say Florida had information that Mr. Betterman had a sexual relationship with a 16-year-old when he lived in Minnesota, and then Florida said, well, we would like you to register based on that. He shouldn't have to register because that wouldn't have been a crime in Minnesota. And it describes similar crimes. So he wouldn't have been committing a crime. He was committing a crime only because he was her coach. And again, also, this is where I believe the appellee's argument fails in addition, because the appellee says it's difficult to imagine someone being convicted in Florida, not being convicted in Florida if they're convicted in Minnesota, but the converse is not true. In Minnesota, it would be lawful to have sex with a 16 or 17-year-old, but it never would be in Florida. Furthermore, Florida's statute requires familiar or custodial authority, whereas Minnesota's requires position of authority, a broader term. And this is where the definition of similar becomes so important in the case. The state in its answer, rather the department, keeps saying it's hard to imagine the facts of one not fitting a conviction in Florida. But the courts have said, and I believe it's, pardon me for losing my place here with these glasses, the Dautel case from the Florida Supreme Court in 95, 658 Southern 2nd 88. Now this was talking about scorable offenses, but it uses the same language, similar. It said for an offense to be scorable, it's not based on the underlying conduct that occurred in the other state, but rather the elements of the offenses. So there's the legal fact there was a conviction in the other state. Now we have to compare that to the Florida statute that we think is at issue and see if they are similar under the law. The Gershon case, which the appellee correctly points out, Gershon was later convicted, but the Gershon case is important because it applies the same reasoning from Dautel to sex offenders. It's saying if you're going to make someone register, similarity has to be based on the offenses, not the conduct. So here we have one offense that makes otherwise lawful conduct only unlawful because he's her coach. And Florida does not have that. Florida has an enhancement to something that's already a crime. And so there where we're saying, is that strictly comparable? If the court were to apply strictly comparable, which would be the most favorable definition of similar, because we do argue the rule of lenity applies here. It's a criminal statute. You go to prison if you do not register. So he should be entitled to the most favorable definition, he being the appellant, pardon me.
Yeah, but we've already held that having to register is not part of a sentence, so that necessarily lenity doesn't apply.
Well, yes, the court has held that registration is not part of a sentence, that the registration statute, in fact, is constitutional because it's designed to protect the public, but it contains a criminal punishment for failure to do so. So if my client, of course, followed what a citizen should do when he was informed, even though he disagreed, when he was informed he should register, he registered and then went through the process to legally appeal it. So he followed the law and did that even though he disagreed with the law. But for someone to say, I don't agree with this law, I'm going to ignore it because I believe it's wrong, they would be charged, and then our argument is at trial on that case, they would be entitled to the same rule of lenity argument that this is not a strictly comparable statutory scheme that I'm accused of violating here. The appellee points out on page 5 of their answer brief that the Acevedo case from the Florida Supreme Court says similar does not mean identical. And again, I'm not saying they're making a straw man argument, but I want to be clear, the appellant's position is not identical, but we're asking for strictly comparable. And we're saying it's not strictly comparable because there's a different definition of authority, and one is an enhancement to an already criminal conduct. The other is criminal conduct only because of the position of the parties, which would otherwise be a lawful sexual relationship between those parties. So that's not what we're arguing, that they must be identical word for word, line for line, but there's a difference in the definition of the authority position of the figure, and there's a major difference here is it's only a crime because of the position of a coach. And Florida could do something similar. In fact, maybe should. Some people would probably think should. Florida could say our age of consent is 18. Many girls and boys in high school are still 18. Some people are even 19 before they go off to college. And a lot of people might say it might be in society's interest to say we don't want coaches or teachers engaging in sexual relationships with them, even though anyone else could because they're 18 now, because we do feel that there's a level of coerciveness that could be present in that relationship. So Florida could pass a statute like that, in which case it would be like Minnesota. It would be creating an exception to its general rule of consent, which is 18 here, 16 there. And that's what Minnesota did. Any other relationship, if Mr. Betterman had met the victim in that case in any other way other than being her coach, he obviously never would have been charged with this. Whereas in Florida, it would have been illegal under any circumstances. So that's where we're saying, are they strictly comparable? No, for those two reasons, they are not strictly comparable. Unless the court has any other questions at this time, I'll reserve my time.
Okay, thank you.
Thank you.
May it please the court. Good morning. My name is Matt Casey. I'm an Assistant General Counsel with the Florida Department of Law Enforcement, and I am representing the appellee in the case as well. This is my first time appearing before the court. I think it may make the most sense at this point to address the second issue in the brief first, since it was already discussed in reference to the rule of lenity and whether it applies. Our position would be that the language that's in the sexual offender registration statute is very clear and unambiguous. Typically, looking at the case law that was cited by the appellant as well as the case law that we cited, the rule of lenity is generally only applied as a last resort when looking at the statute is so confusing. And typically, from what I saw, it's because usually it was a phrase that was confusing in the statute. In this instance, it seems very clear the language here requires that the trial court do exactly what the trial court did, which is to look at the elements of criminal sexual conduct in the third degree from the Minnesota state statute and look to see if those elements were similar to the offense of sexual battery by a person in familial or custodial authority under the Florida state statutes. So again, and it also appears from the case law that both the appellant has cited as well that we cited, that the Florida courts have really not had any difficulty in applying, or making a determination of whether an out-of-state offense from another jurisdiction is similar to a Florida offense. And so again, I think the trial court properly did that. He listened to the arguments, the same arguments largely that we are making today. He heard those during a hearing. He compared the elements of the offense from criminal sexual conduct in the third degree of the state of Minnesota with the elements of the sexual battery by a person in familial or custodial authority, and he found that those elements were similar enough to meet the requirements of the sexual offender registration statute here in the state of Florida. And so in that regard, there's really no need to apply the rule of lenity. I think it's been cited in many of the cases that we cited to the court in the briefs that similar really means analogous. And in the analysis in some of those cases we cited, in Dotel, Acevedo, again, the analysis was typically, were the offenses analogous to each other? So I would submit to you that because it's very clear what the definition of similar means, that there's no need for the rule of lenity to be applied. And again, it is a rule of statutory construction that's really only to be applied in a last resort if it seems very unclear to the courts what the legislature meant.
Could you address appellant's argument that they're different or not similar because of the enhancement? In Minnesota, it's an enhancement. In Florida, it's not. Could you address that? And is it your position that that doesn't make any difference? We look at the elements of each state and just compare them pretty much in a chart to determine whether they're similar?
Yes, Your Honor. I would argue that it really doesn't matter whether it's termed as an enhancement here in the state of Florida or not. Again, I believe the Dotel court noted that, again, we don't look at the severity of the punishment when comparing the offenses or even the degrees, the maximum possible punishment. Instead, the analysis is strictly to lie in comparing the elements of the out-of-state offense with the elements of the offense that is similar in the state of Florida. And so when you do that, and I think maybe the best way to explain it, and I know counsel for the appellant has already sort of said this, but I think it's abundantly important in this instance that I would argue, because we're not supposed to look at just the facts of this case. In this case, the appellant was a wrestling coach and the victim was a student who was 16 and 17 years old, and he was 30 and 31 years old when they carried on a sexual relationship. And so clearly it met the requirements of the statute in Minnesota for criminal sexual conduct in the third degree. But in doing the analysis, again, we don't look at those facts. What I would submit to the court we do is we look at the facts of sort of if any defendant committed the offense of criminal sexual conduct in the third degree in Minnesota and then came to the state of Florida and continued that relationship with the victim in the state of Florida, then they would be subject, I would argue, each and every time to being charged with sexual battery by a person in familial or custodial authority. As we pointed out in our brief, it would be hard to think of any factual scenario where someone could commit that kind of conduct in the state of Minnesota under criminal sexual conduct in the third degree, and then when they can't come to Florida, if they committed that same course of conduct, that it would not fall under sexual battery by a person in familial or custodial authority. And again, that's based on taking the statutes and taking, more importantly, the elements of the statutes as required by Dotel and going through those. And when we do that, which we laid out in the brief, you see that the elements are not identical, but again, they are not required to be identical, but they are very similar. And so when you look at the first element of criminal sexual conduct in the third degree, it requires that the defendant engaged in sexual penetration with another person. And then in the state of Florida, the first element requires that the defendant engaged in any act which constituted sexual battery. And the Florida statutes go on to define sexual battery, and that definition includes penetration. So again, to sort of further illustrate the point, it would be hard to think that anyone committing sexual penetration in the state of Minnesota wouldn't also fall under the first element of sexual battery, 794.0118B, in committing sexual battery, because the definition of sexual battery would include sexual penetration. So those first elements, although the language is slightly different, would basically cover the same conduct. And then when we move on to the second element of criminal sexual conduct in the third degree, that requires in the state of Florida that the victim is 12 years of age or older, but younger than 18 years of age. And then when we look at the second element of criminal sexual conduct in the third degree in Minnesota, it requires that the victim be at least 16 but less than 18, and the actor is more than 48 months older than the complainant. So although I would agree with counsel for the appellant that Florida's statute as to the second element is broader, because certainly it would include victims from 12 to 15, I think what's more important is noting that it includes 16 and 17-year-olds. So again, any victim in the state of Minnesota would also be still a victim in the state of Florida. And so although Florida's statute is broader, encompassing younger victims, it still would, the second element would cover any victim that would also be a victim under the statute of criminal sexual conduct in the state of Minnesota. So again, the second elements are not identical, but they are similar in that they cover the same victims. Plus, in Florida, we cover some additional victims, which would be from 12 to 15 years old. Looking at the third element, when you look at the third element in the Florida statute, it requires that at the time of the offense, the defendant was in a position of familial or custodial authority to the victim. When we look at the Minnesota statute, criminal sexual conduct in the third degree, it requires the defendant to be in a current or recent position of authority over the complainant. So again, we would argue, although the definitions or the wording of the elements are slightly different, again, it would be difficult to imagine that in any prosecution in the state of Minnesota where the third element was met factually, that it wouldn't also, if the prosecution was in the state of Florida, those same facts would meet the third element in the state of Florida. And so I think when you kind of walk through, which is what we asked the trial court to do, and to look at each of the elements and to compare those elements side by side, that ultimately what the trial court determined was that although the elements of the two offenses were not identical, that they were similar enough, which again, we would argue the definition of similar is analogous. Another definition is to resemble without being identical. And so I think that is the well-known, plain and obvious meaning of the word similar. And when the court did that, when the trial court applied that analysis, he saw that the elements really line up very closely to each other. They're not identical, but they're similar enough. And particularly, again, I think just kind of wrapping it up, it's just very difficult to imagine if someone committed a course of conduct in the state of Minnesota and was subject to prosecution under the criminal sexual conduct in the third degree statute, that had they committed that same course of conduct in the state of Florida, they would not also be subject to the charge of sexual battery by a person in familial or custodial authority. And we would submit, based on what we argued in our brief, as well as I'm arguing today, that when you consider all of that, that the trial court ruled appropriately. He appropriately denied the petition for writ of mandamus, and that his ruling should be affirmed by this court. Unless the court has any additional questions for me, I think I will wrap up at this time. Thank you.
Mr. Brown?
Counsel, please, the court, just some brief rebuttal to that excellent argument. Judge Thomas, I believe you asked a question about the difference between an enhancement here and creating a crime.
And I probably misspoke. I should have probably said exception or enhancement, but I think that was your argument.
Yeah, and our argument's twofold. That's the main, the other being the difference between the type of authority that's involved. But so that is the key argument here is Minnesota. I know I'm repeating myself, but I just want to, this is our main point. I want to bring it home one more time. Minnesota's statute creates a separate, distinct offense. for people that otherwise can lawfully consent to sex with an adult. In Florida, people 16 and 17 years of age cannot do so. Minnesota's is a separate offense. So if the term strictly comparable, which we're asking the court to apply, is used, is that strictly comparable? It is not. Florida's subsection, which is being cited, is an enhancement to an already existing law. It raises it from a second to a first degree because of the power of dynamic between the two folks. And then also, again, there's a difference that Minnesota uses the broad term position of authority covering a coach at a school. Florida uses familial or custodial authority, exercising those types of authority. Again, not strictly comparable. I would try to use the analogy, and without being facetious, is, let's talk about another important purpose in life if we're looking at the rule of lenity. The key case says an unresolvable ambiguity is needed to use the rule of lenity. And again, we're not talking about the entire statute. We're saying the rule should apply to the word similar. The fact that we're sitting here arguing over what similar means almost kind of proves the point. And the analogy I would use is if I'm a stockbroker, a wealthy individual comes and says, here's $1 million to invest. I don't know a lot about the stock market. And I would say $1 million is very important to somebody, just as this issue is very important to my client. And they said, I would like you to get Microsoft, Google, or some kind of similar tech stock. And I think I would stop and go, what do you mean similar? Because before I invest your money, I don't want to be held accountable for something you didn't want to do. Similar is a very vague and broad term. Both of us have thrown out several definitions. That's why the appellant should be entitled, because of the fact that there's an unresolvable ambiguity here, that the court should use the definition strictly comparable. Again, we're not asking for identical. We don't think that that's appropriate. The words similar and identical are obviously not the same words. Legislature would have said identical. But when they used the term similar, they left it open to interpretation, unfortunately. Counsel made the point, if this relationship had continued at the time when the victim was still not 18 and they had come to Florida, it definitely would have constituted a crime in Florida. That's true, but the example that we used is if he was not her coach and they were having a sexual relationship in Minnesota, it wouldn't have been a crime there, and it would have been a crime in Florida, which is exactly our point. It's per se a crime in Florida. Florida statute only enhanced the section that they're talking about, which is, I believe, 794.011 sub 8. So it's sub 8 of the general statute enhances an existing crime, which was not a crime in Minnesota, and so not strictly comparable for those two reasons. Thank you for your time today.
Thank you both for your argument this morning. Counsel are reminded to meet with us for coffee in the rotunda during the break, and we shall stand in recess.
All rise. All rise.
Please have a seat. All right, our next case is Robert Friesen versus State of Florida Division of Risk Management, and it's 21-1353. Mr. Fox, are you ready? Yes. You may proceed.
Morning. May it please the court. My name is Jason Fox. I'm here for the appellant Trooper Friesen. I'd like to reserve 4 minutes for a rebuttal. This is a hypertension case under Florida Statute 112.18 for a presumption type case for hypertension. It's uncontroverted that the claimant had the appellant had met 3 of the 4 elements that are required for the presumption. The 4th element, being the disability element, is at issue, and the appellant believes that we've satisfied that in 3 different ways or methods, and that the lower court erred in not recognizing that. The first and foremost is that the appellant was at the doctor for a regularly scheduled visit, but that visit basically was transformed or changed. The nature of the visit was changed when the appellant was held in the doctor's office by the doctor due to his blood pressure being so high, being a 160/140. And that being physically held in the office was a restriction, in fact, by the doctor. It basically, again, transformed and changed the nature of that visit on February 12, 2019.
Was that a restriction or was that observation?
Don't believe that was observation. He was being physically held. The appointment was scheduled for 15-20 minutes, spent 15 or 20 minutes with the doctor. He was then sat down for essentially another 45 minutes and told not to leave, and they waited for his blood pressure to come down before they would allow him to leave. So
your position is, had he not been held there till his blood pressure went back down, he would have gotten his patrol car and logged back in on the radio and gone out and looked for bad guys?
Correct. And even though that was only a 45-minute period of time, being held by the doctor in his office for the blood pressure was a temporary disability. It was a time where he was not allowed, not authorized to work, or not released to work by the doctor, and being held was essentially a form of treatment, not just observation, because they had to wait for his blood pressure to come down and before the doctor would release him. Unfortunately,
But the doctor didn't tell him, don't go back to work today, or don't go to work tomorrow, or for the next week, stay out. He didn't say anything like that.
No, the doctor didn't give any note, any clearance one way or the other as to what a restriction or non-restriction or follow-up would be required at that time. So we believe that would absolutely be just in the plain look and plain meaning. The doctor was restricting, not just observing, but restricting the appellant from returning to work for that time frame, and that would qualify as a disability under the case law and definition.
So, counsel, what if this regularly scheduled doctor appointment on February 12th had been scheduled for a day that he was off duty? Would you have an argument?
Yes, I don't believe that there's any difference, again, requiring that he be on duty or off duty or not on vacation.
So if the doctor said, before you go out and run your errands and go to the grocery store, just wait and see if we can get your blood pressure down, that would, in your position, is that would be a disability? Yes,
because I believe the reading of the case law and the way that the statute reads and has been applied is that, again, it can be a disability even when they're not working, not on the clock. There have been cases, I don't recall the name of the case, but I know there's a case where someone was on vacation when they had the incident. Just because they're not on does not mean that they do not have the disability. And with Trooper Friesen, he's on call. He's always basically subject to being called in for a traffic homicide, which is what he does, traffic homicide investigation. So he's technically on call for that.
Well, certainly a law enforcement officer, if he was, on vacation, he was in Maui, and he met all the requirements to be covered by the heart-lung bill, and he had a heart attack, and he had to spend some time in the hospital. That would be some amount of disablement. So,
Yes.
But I'm trying hard to get there when the only thing that really happened is, hey, you just sit here for a few minutes. We're going to take your blood pressure. If it's still high, we might have to do something, but if it goes down, we'll just let you go. I see a big difference between those two scenarios.
I do as well, where there's the clear disablement, where hospitalized, whatever it may be, for a heart attack in Maui. But in our situation, again, he was physically being retained by the doctor, unable to go into work. He was supposed to work from 11 to 7 that day. He did take the morning off to attend this appointment. But again, we believe that the nature of that appointment, basically it changed when it went from, okay, you're here, let's review the EKG, the echo, everything is.
Did he go to work
right.
that day?
He did go to work. He went to work late at, I believe, 12 or 12:30, and he left early. He left at 5 because he wasn't feeling well. But we believe that time, just in and of itself, by being held by the doctor, would be restricted. He was held out of work. He could have gone to work if the appointment started at 11, at 11:15 or 11:20, had the doctor not restricted him from leaving for his blood pressure.
We've got, I think, Bivens is controlling, and then we've got the Roca and Battle opinions that follow Bivens. In Bivens, we clearly said a finding of disability hinges solely on the employee's ability to earn income, not upon other factors such as whether the employee experienced wage loss. And now, I see these cases as very factual, very factually specific, but why isn't Bivens controlling in this case? And I don't see that Roca or Battle deviated from Bivens' announcement at all.
Basically, in Bivens, following Bivens, following Bivens, we believe that he did not have the ability to work while the doctor was sitting him down for that time frame or that time period. Unfortunately, again, the doctor, in restricting him, took away that ability. And we think it's more like Roca, where he retained the physical strength and the coordination to perform the job, but basically the doctor didn't say, well, you're restricted, but he did in effect restrict him, sat him down, held him back.
Right. Well, I think what I find important in Roca is it's a very carefully written opinion in my review, and the limited question, and the panel was quite clear, the limited question in Roca was whether a claimant can rely solely on a medical restriction to prove disability for purposes of 112.18. That was the specific question. And they said in Roca, under those facts, there was a work restriction imposed due to an already diagnosed hypertension, et cetera. So I'm seeing a distinction in this case, or the case where a heart cath required 3 days of recovery, that it's the condition's been diagnosed, or there's an invasive procedure, and that condition in Battle, for example, which is caused by that injury, resulted in the restrictions and the time off work. Where do we have that here? Where do we have that same set of quite narrow facts? The
hypertension, the high blood pressure, was the cause for the holding back or the disability. And Bivens can be separated from this case, because in that case he was restricted, in Bivens they were restricted for I believe, a microvascular angina, not hypertension, and he had chest pain, shortness of breath. None of those other conflicting issues here. We hear it was just for high blood pressure and hypertension that the doctor held him out, and that's what the claim is for and what the disability was due to. So we think that that's all related that way. But we believe that there's two other ways that the disability was also accomplished, in that the doctor had indicated that in review of the records that the blood pressures in and of themselves were in excess of the JNC guidelines, the ACOEM guidelines, and that anyone that would have a diastolic as high as 140 should have been restricted from work. That it's just a de facto that it should have been, he should have been restricted. And the third way that we believe we've proven the disability is that Dr. Perloff, in performing his independent medical exam, essentially had applied the facts as they were to the objective medical standards and provided a uncontroverted medical opinion. Again, there's no other medical opinion here in this case, and he assigned restrictions.
In looking at the cases, I think it's fair to say that arguably there may be some inconsistencies in this court's line of opinions regarding how we define disablement. But in your opinion, as we stand today with the case law that we have, is it your position that disability requires evidence of actual wage loss, or is disability only the ability or vocational perspective of ability to return to work or similar work?
I believe it's just the ability to perform the position or the job, the work. And for first responders, it's to perform the entire breadth of their work. They cannot have any restrictions, or they cannot do their entire job. So they need to have essentially no restrictions. I don't believe that it would be a wage loss requirement, because many of our clients are salaried, or basically suffer the disability if they have a schedule that's 24 on, 4 days off, on a day or 2 days that they may be off. So there may not be wage loss, but they may be restricted during that time. They may have restrictions placed upon them, and they may not be able to go in. Firefighter, if there was a 4-alarm fire and they all had to be called in, or if there was a emergent school shooting that all the officers were called in, if it's one of their days off, they may have that ability or non-ability to do the job, and there wouldn't be any wage loss, to answer your question. As I've exceeded the time I wanted to reserve, if there are no other questions, I'll reserve further. Thank you.
And I will give you an extra minute, because you were asked questions right at the end that you need to fully address. So you'll get your full rebuttal time you asked for. And Mr. Tinker, you will have an extra minute added to your time if you need to use it.
Thank you. May it please the court. Good morning. Mark Tinker on behalf of the State of Florida Highway Patrol Division of Risk Management. I think the issue that's before the court is pretty narrow, and I know it's been thoroughly briefed, but there's one thing that there was a dispute in the briefs that I think we need to discuss first, and that's the court's standard of review. The initial brief labeled it as de novo review. In the answer brief, we pointed out that we believe it's competent substantial evidence. And I believe that this court's case law indicates that when you're interpreting the statute, for example, as in Bivens, the case we talked about, the question there was whether a form of hypertension actually fit within the statute, whether it qualified. The court said, well, we're interpreting the statute. That's de novo review. That's a pure question of law. But when you're looking at what the JCC did here, if he's looking at the evidence and when he reached the determination of disability, because we know what the statute does is the statute creates a presumption of occupational causation. It does not relieve a claimant of proving that this injury caused a disability, as that's been defined by the courts. So when the judge is taking that definition that the court has established and making a factual determination, looking at the evidence presented at the final hearing, did this satisfy the definition of disability, That's something that he's applying the evidence, and I believe that the standard that this court should be looking at is there competent, substantial evidence to support the conclusion he reached. And I believe that there is the main issue that's been discussed, the first issue anyway, was this office visit with Dr. Gupta, that it was a regularly scheduled visit, just there for some diagnostic testing, and the argument is, well, it transformed when he was held. And I think, Judge Thomas, I think you said it correctly, there was observation that was taking place. What Dr. Gupta did, he reviewed the test results, the EKG results, he took the blood pressure, made a medication change, observed him for an hour, and then released him with no restrictions to go back to work, which means the blood pressure regulated itself. That's what the doctor was looking for. He said, I need you to sit here for a little while. Your numbers are high. Let's see what happens. If it didn't regulate itself, then he probably would have been held. He probably would have been restricted. He would have received some work restrictions moving forward, but he wasn't. He was cleared with no restrictions to return to work that very day, and he did. And then I believe he took a couple of days off to deal with family issues and then went back to work and worked for years at this point after that with no work restrictions in place. So that was an observational visit. He said, let me see what happens with your blood pressure. It looks elevated now. Observed him for what we would consider, I guess, 45 minutes, 40 minutes, released him to go back to work. That's not holding someone within this court's definition of disability. And I know there was also a question that was asked, well, is the case law somewhat inconsistent? What qualifies as a disability? I agree with counsel. I don't believe wage loss is the issue. And I think City of Mary Esther versus McCarter is a case that kind of deals with that, where it looked at the fact that somebody was placed on work restrictions but was nevertheless paid. And the court said, well, it's not an issue of payment. It's whether you have the capacity to earn money, the capacity to return to work, and even in any other position and earn the same as what you were making before. So it's a capacity to earn issue. Here, there's never been any questions about capacity to earn. There were no restrictions placed on him. Went back to work and performed all the same functions.
I'm interested in your opinion on the use of the term disability is throughout Chapter 440, and we have the term disability under the Social Security standards for PT, for example. Is there any argument that you could present that says there's a difference in the definition of disability in terms of how it's used in say, PTSD analysis versus here under the definitional section, or is that enhance the definition as a vocational analysis as opposed to strictly a loss of wages in each case?
I think it's a vocational analysis and I think what would be important, even if the definition has been, or the word has been defined differently, is that the court has established precedent at this point that litigants are following, that everyone knows that is the definition in this context for this statute, that it is the inability to return to work and the inability to earn a wage. So even if it is looked at differently in other contexts where it's used in, that would have different meanings, here, this is the statute exists to relieve the obligation of proving occupational causation. So disability is the second part of that, to say, okay, if you don't have to prove causation, you at least have to prove that your injury prevented you from working, because that's what workers' comp exists for, is to compensate people if if they don't have the ability to return to work. So it's not about actual wage loss, as counsel suggested, that people can be salaried, they might not have lost wages, an employer could voluntarily pay someone. It's not that issue, it's the inability, the incapacity to work in this context.
Well, I think, an irony in these cases is that you're talking about the definition of disability in terms of loss of earning capacity or loss of wages, yet in all of these claims you have a complete absence of indemnity benefit requests. It's always a medical benefit request with no request for any indemnity benefits. I think that's one of the ironies that I see in these circumstances.
And I don't say I disagree with you, but I mean, as I said, that's in this context, that's what it exists for, is to say if you're relieved of the obligation to prove causation, you have to at least prove that the injury at issue prevented you from working, which I think is a reasonable standard in this context for this statute, and that's what the case law bears out, and that's what the precedent is at this point. I think the only other issue that I can address that council brought up is the subsequent test, or the subsequent opinion by Dr. Perloff, someone who 2 years after the fact performed. It was a virtual visit. He didn't even physically, examine Mr. Friesen. He performed this virtual visit. He said, I think I would have, based on these objective standards, I would have placed restrictions. If we go back to what we've just been discussing about the definition of disability, what he in hindsight would have done does not change the fact that there were no restrictions and that Mr. Friesen actually did return to work and actually continued to work that entire time, even up until that virtual visit, was still working in full capacity, never lost the ability to earn wages. So I think, especially go back to my initial point, if the Judge Massey's looking at whether there's competent substantial evidence to support his conclusion that that opinion after the fact and, in hindsight of what one doctor would have done doesn't change what was actually done. And so he appropriately resolved that conflict. I think other than that, I would be repeating what's in the brief. So unless the court has any other questions, I thank you for your time.
Thank you.
Thank you. Brief rebuttal. Basically, the disability by Dr. Gupta was temporary in nature. We did not believe it would be possible to even file for a temporary partial for the 40-odd minutes that he may have had a temporary disability for that time frame. Again, we just proceeded with the seeking of compensability of the case in its entirety. With regard, we believe that the judge, the lower court, erred in calling Dr. Perloff a speculative hindsight or Monday morning quarterback. His opinion was completely scientific. There was no question as to the facts that the appellant had a 160 over 140 blood pressure on the date of the incident, and what the methods or standards are that the standards being the JNC and ACOEM, what the standards are for hypertension, hypertensive crisis, and when somebody should be restricted. And we believe it was very clear how Dr. Perloff applied the facts to those standards. It's something that was not speculative at all. It's not hindsight. It was the facts. Those are the standards. It's something that's reproducible, and the doctor should have done on that day, and he didn't do it appropriately or well. And the appellate should not be punished for the doctor at the time, Dr. Gupta, not doing that appropriately. But also the opinion by Dr. Perloff then is not speculative. This is not something where he's subjectively saying, I would have done this. This is a very clear formula utilizing the facts that we have in this case. The employer carrier also did not have an independent medical exam. They did not have an authorized treating physician. There's no medical evidence to dispute the objective medical standards in the JNC and OCM, and there's no explanation for why the judge did not acknowledge, or the court below did not acknowledge and recognize those as the standards, as it was uncontroverted. And just note in the argument that Dr. Perloff is speculative, saying he would have done this. Well, it's the only way to phrase that, because he's talking about what had previously happened, but he's explaining how it fits into the formula. Any independent exam that's done after the fact has to opine, this is how I would have done, or this is what should have been done. It's all going to be in past tense. But in this case, the judge provided no basis as to why the lower court rejected the uncontroverted testimony opinion to the objective medical standards, or to Dr. Perloff's assigning a restriction and thus providing a lost capacity or incapacity for the appellant. And the lower court only indicated that it was hindsight, which is not accurate. This interpretation would leave of an IME would leave claimant without a way to prove a case or a way to have any recourse if a doctor is unaware or a doctor disregards objective medical standards, it could essentially eliminate cause of action if the IME is applied in this way, in this thinking by the lower court. But again, we believe that the blood pressure in and of itself with that diastolic of 140 was disabling, and further that the lower court erred by failing to accept the uncontroverted opinions and classifying Dr. Perloff
Just
as
to
speculative.
clarify something, when the claimant went in for this testing, it was accepted actually under an old date of accident several years before, but it was accepted under the 120-day rule, correct? So compensability had been conditionally accepted of the hypertension condition at the time this evaluation occurred.
Under a prior date of accident, not the
Right.
date of accident at hand, yes, sir.
And then a notice of denial was timely filed or within the 120 days, and then later the petition we're here on today was filed with a different date of accident.
That's correct, Judge.
Okay.
If there are no other questions from the court, I appreciate the time. Thank you.
Thank you both very much for your argument. We have no other cases to hear this morning, so we're adjourned.
All rise.